name is. We also call Maria Patino, if I'm pronouncing it right, and she's in the public also.
Hi everyone, thank you so much for having me. I want to put a face to these bills that my friend just mentioned, and I want you to think about me as a constituent living in Columbia, Alabama, as a mother of 4 kids. I trust my law enforcement. I can call the police if I'm afraid, and I want you to put in your mind, what do you want to do with this law, with this bill? Is it scary to any person? Like if I want you to think that if something happens to me, how do I trust my police officers if I know this bill is in place? How do I call them feeling, I'm just talking right now, I'm shaking, just thinking about it. This is not fair. You represent me, you represent everybody in Alabama, and I want you to please start thinking in our safety the way that you are thinking in our safety, in everybody, in the people who live here in Alabama. We live here. I don't know what you see when you put these bills against my community. What do you see when you see me? I want you to start thinking before you bring these laws or before you bring these bills here, because we are in 2025, and I can't believe it that we are having these conversations against people, against my community. So I want you to please think about this bill. If this bill pass, you put my community in as an easy target. How do you say vulnerable? Because how are they going to call the police? If this bill give the authority to the police officers to work with immigration. It's not fair. So I just wanted to please every one of you to think if you really want to give this vote. I know the person who put this bill, he wants to, fix a lot of problems. I understand, like I say, I'm a mother who worry about my daughter's safety, and I wanted to remember about HB 56. I was here. And many of my friends left because they were afraid. No many stay here to fight. A lot of people will stay here and fight, okay? But not many couldn't stay because they were afraid and they left. Okay? So if you was not here when it was 2011, I want you to start, talking to people so you can see how hard it was back then when they passed that bill. Thank you so much.
Thank you, Mr. Taylor. Does any of the members of the committee have any questions to be addressed to the various three speakers? If not, the amendment that Representative Yarborough has going to be introduced next week, and that concludes the public hearing on HB 7. At this point, I'm going to turn the hearing back over to Judge HB.
Thank you, Mr. Wadsworth. I appreciate you taking over. I had a bill I had to deal with in Ways and Means, so we're now going to have a public hearing on HB 8. Representative, yes, ma'am. Please come up and explain the bill, please. Representative Garland, talk about HB 8.
Thank you, Mr. Chair and the esteemed committee. This bill is identical to what we had in session that passed out of this committee on last session and got on the Senate's floor, and because of other things, it did not even come up in the Senate. And it's the same bill that will help us not only to be able to regulate vaping, but it will give us the enforcement dollars to be able to do so, create about $2.5 million for ABC as well as Aaliyah to vape. It will create some gestation programs for those violators that are in school. But this is the same piece of legislation this committee passed last year. That's it, Mr. Chair, and I entertain any questions.
Anyone have any questions for Representative Garland? We see none. I think we've got some people who want to speak.
Thank you.
We have 4 opponents. Mr. Gregory, I'm going to let 3 of them speak. So which 3 you want? I'll go first, okay?
Thank you, Judge, members of the committee. I'm Randy Graffner. I represent the Baker Technology Association, which is a trade association that works on behalf of the baking industry. First of all, we fully support what Representative Drone is trying to do with the regulation of the baking industry. However, it's our contention that there's some language in this bill, specifically on page 30, lines 25 through 29, that's intended to protect the tobacco industry and its combustible cigarette, thus giving a competitive advantage to the cigarette market to the exclusion of the baking products. The relevant section in the bill is 2811-17.1. As you will see, subsection C is the newly added language from the existing law. In the context of that statute, sets out the statutory requirements of people who can sell vaping products in Alabama. You have to have applied for a pre-market tobacco application with the FDA. I'm glad to answer your questions about that. If those of you don't know what that is, but talk about it after just due to time constraints. Nevertheless, the way the language in the bill reads is, if you meet all these requirements, then you are allowed to sell in Alabama. However, there's two sentences in there that disqualifies single-use vaping products and those with cartridges. Those are referred to in the industry as closed system products, meaning you see people ride around with the big handles of stuff and you can fill that up yourself. That's known as an open system, whereas the others are closed systems, single-use vape product or a cartridge that's inserted into the product. Well, the language specifically excludes those single-use products to account for over 95% of the market in the sales of vaping products. So it's our contention that with this language, you're given, again, protecting the combustible cigarette to the exclusion of the vaping industry, the single-use products. So it's our contention, if we make the requirements that's set out by state and federal law, then we should be able to sell these products in the state of Alabama without giving priority or deference to the combustible cigarette. So that's all I have to say. Thank you, Judge.
Mr. Thomas?
Good afternoon. I'm Randy Tom. I serve as superintendent for Winfield City Schools. And I'd like to share with you what we've seen over 4 years of vaping in our school district. We have traditionally a top 10 school district in the state of Alabama, and we've lost a lot of instruction time with vaping, especially with our middle school students. And taking you through a 4-year period of that, in 2021 we saw an uptick of this, and so we started talking to our children. Why are you doing this? Where are you getting this from? After speaking with them, we started speaking to our local law enforcement. We talked to our school board attorneys, to our district attorney, and to our judges. And so we use a call-out system called Thrill-Share, and we established a parent meeting and told them that it was our purpose that Governor Ivey passed in 2021 that if you are under the age of 21, it is illegal to possess a vape. So we started telling our parents that what we're going to do is call law enforcement, and they will come and write a citation for your child. When that happens, you will have to go to court with them. And so we've been practicing this over the last 4 years. We also had assembly meetings with our students, and we talked to them. And we told them, now we had the parent meeting, but all of you didn't show up. So after I talked to the last student group, and being in a small town, they all knew me. I said, I'm going to confess my sins. I was your age once. I smoked cigarettes. I tried alcohol. I didn't do dope. And they said, what's dope? And that aged me a little bit. I had to explain that. And I said, but I did it probably because of either peer pressure or because I got a rush from doing this because I was doing something I shouldn't do. Y'all are doing that for the same reason. Peer pressure, a rush, or it tastes like vanilla ice cream to you. And if it's that third day, you got a problem. So we started talking to our children, started with citations. 4 years later, this year in high school, we've had 3 vaping incidents. In the middle school, we've had very few. We have put in vape detectors. Vapes do not belong in our school district. Thank you.
Thank you, sir. Mr. Albers?
Ms. Albers?
Ms. Albers, I'm sorry.
That's okay.
Hello, everyone, and thank you for the opportunity to speak to you today. My name is Amy Alberts. I'm a business owner in Birmingham, Alabama. I'm also the vice president of the Alabama Hemp and Vape Association. My husband and I have owned our vape business since 2013, and we've worked together to build a trusted 21-plus establishment and have helped thousands of Alabamians quit smoking. Before transitioning full-time to our business, I worked as a medical laboratory technician for 26 years. I'm registered with the American Society for Clinical Pathology and the American Society for Clinical Laboratory Science. For decades, I've analyzed the effects of disease on the human body, interpreting diagnostic tests and seeing firsthand devastating impact of smoking-related illnesses. I know what smoking does at a cellular level, and I've seen the suffering that it causes. That is why when I left the lab in 2021 to focus on our business, it was with the same goal, which is helping people improve their health. Our shop has always been a place where guests can receive education and support as they work to reduce or eliminate their nicotine dependence. But HB8 threatens everything that my husband and I work for. This bill does not protect public health, it protects big tobacco. Year after year, this bill has been introduced, and the only winners are cigarette companies that stand to regain their customers by eliminating 90% of the inventory that specialty vape shops like ours carry. HB8 would impose an unnecessary product registry designed to make it impossible for small businesses to operate. It unfairly groups 21 and up specialty vape shops with convenience stores. Despite the fact that our industry has implemented self-regulation, ID verification, and strict age restrictions that go beyond what is even required by law. We are not the source of youth access, yet we are the ones being targeted and affected the most. The reality is that youth vaping rates have already declined, as you heard from the gentleman that spoke before me. The best way to address underage use is not through overreaching bans, but by ensuring that vape products are sold exclusively in 21 and up establishments like ours. And if that were the case, the youth access problem would probably be about 95% solved. It's not that we're against regulation. We're just against unfair regulation. We need reasonable policies that distinguish between specialty vape shops and convenience stores. We need fair permitting and registry requirements that do not destroy small businesses while allowing big tobacco to thrive. We need to ensure that non-nicotine substances like CBD are not included in the language of this bill, as they do not even fit the definition of an ENDS product, ENDS, electronic nicotine delivery system. And most importantly, we need legislators to work with those of us who are directly impacted. And this is what's most important to me and to my colleagues. The HVA and its members want to be part of the solution. We're the ones who deal directly with the public. We take our responsibility very, very seriously, and we actively prevent youth access now. We educate consumers, we support responsible legislation and regulation. We want to work with legislators to identify the real problems and craft their solutions that actually address youth access without destroying businesses like mine and taking away adult consumers' choices. In closing, HB8 is not a public health bill. It is a corporate protection bill, and I urge you to stand with small businesses, stand with the thousands of Alabamians who rely on these products, and vote no to the language on this current bill. Thank you very much.
Thank you. I have two more folks that want to speak, and one of y'all like to speak. Jump on. State your name, please, ma'am.
Thank you, Mr. Chairman. My name is Molly Cole,
and I represent the Alabama Hemp and Vape Association. I would like to express some concerns about HB8 in its current form and to propose necessary amendments that would ensure fair and effective regulation for this industry. However, I do want to start off by just providing a little bit of information that over the last 15 or so months, with the tobacco compliance that have been checked through, 315 records have returned that have shown that youth access has been allowed. However, this has been in your convenience stores, this has been in your gas stations. Of this 315 number, only 6 of those have been found in our southern Alabama stores for vape products. Those have also since been taken care of. First and foremost, this bill is premature given the fact that we are still awaiting a Supreme Court decision in FDA versus Wages and Line Investments. This case challenges whether the FDA overstepped its authority in regulating electronic nicotine delivery systems. The outcome could fundamentally change how these products are governed at the federal level. If HB8 passes without allowing for this decision, we are risking enacting state laws that may become obsolete or legally questionable within months. To address this, we propose that we're able to extend the deadline and carry this bill forward. Beyond that, HB8 fails to strike a fair balance between regulation and the survival of independently owned vape shops in Alabama. Right now, the bill unfairly targets vape shops while exempting convenience stores. If the goal is to regulate responsibly, then independent vape businesses should be exempted from the definitions that unfairly classify them based on floor space rather than their actual operations. Additionally, we propose that the creation of a disposable vape registry to ensure only approved compliant products are sold, helping law enforcement and regulators track legal and illegal sales. To fund this effort fairly, there's a proposition of $100 per product annual registration fee and one-time application fee that mirrors other states that have the same structure, so that regulation does not unfairly burden small businesses. Further, HB8's penalty structure is excessive, penalizing entire companies rather than individual locations for infractions. We propose amendments that ensure fines are assessed per location, just as they are for alcohol and tobacco violations. Speaking of fairness, HB8 imposes overly restrictive advertising bans that go beyond alcohol regulations. If stores can have neon signs and window advertisements, why should vape shops have or be prohibited from the same? We propose aligning marketing and signage laws that govern alcohol and tobacco to ensure equal treatment for all 21 plus products. Finally, we propose the creation of a prohibition registry maintained by ABC, the Attorney General's Office, and the Department of Revenue to track and update non-compliant products. This ensures effective enforcement without punishing compliant businesses. I also want to emphasize that our goal is not to delay regulation, but instead to get it right. We appreciate that the sponsor and supporters of this bill are open to conversations and recognize the importance of creating an opportunity for all stakeholders to achieve their goals while keeping Alabama's small business infrastructure intact. Because with this bill that moves forward, would damage the small business infrastructure in Alabama. This would harm 10,000 or more businesses.
Thank you, Ms. Cole. We appreciate your input, we really do.
Thank you.
Ladies and gentlemen of the committee, we've had 4 people speak on this bill. We will not take a vote on this today, but I'll certainly allow any member of the committee to ask any one of the individuals that spoke a question if they would like to do so. Please, yes, sir. Representative Drummond, would you please come back up? There's a question from the sponsor.
Mr. Drummond, I wanted to actually give you a chance to respond. There was a common theme from the speakers that were in opposition, and one of the themes was an unfair advantage to the tobacco industry. And the second was the idea of 21 years, and I thought I saw that in your bill, so I wanted to give you a chance actually to respond to that, if you don't mind.
Well, first, I don't think that this bill gives an unfair advantage to tobacco companies. If you all remember what I told you before, when we constructed this bill, we talked to every affected entity possible. We had worked this bill, we worked with tobacco folks, we worked with Voices for Children, anybody who had an interest, we worked with them. The tobacco folks, if you had them here now, they can tell you they're not happy with this bill. We've got to do something about vaping. And as far as small businesses are concerned, many keep referencing the registry. The registry is already the law in the state of Alabama. It is not being enforced. That's why we brought the legislation, because ABC did not have the funds to go out and enforce the vaping laws that are currently on the book. The pre-market registry was actually established federally by the Trump administration, and Alabama came along with myself as well as Representative Stringer. If you go back and look in the records, it's Drummond Stringer's Act, and we have a pre-market registry where they're looking at all of the bad stuff that's being brought out of the China and Mexico. That registry is being monitored by the Department of Revenue. And they have to meet certain criteria. If they get the federal pre-market, they can get on our state pre-market. But all of those claims are, in my book, are not very valid. We're not trying to hurt small businesses. We're trying to save the lives of our children.
Thank you, Ms. Strong. Any other questions for Ms. Strong or any of the speakers? Okay, seeing none, we will close the public hearing. We will not go on this public hearing today. We're off next week. So this will give y'all 2 weeks to talk to the various members of this committee. But we will take this back up in 2 weeks when we come back from our spring break. So if you're here for that bill, thank you for coming very much. By the way, you're obviously welcome to stay for the rest of our intriguing meeting, but, you know, I figured if you're here for one of those 2 bills, that's why you can. Okay, ladies and gentlemen, we're gonna go on with our regular meetings now. We will take those on these next bills. HD 53, Representative Sellers.
Mr. Chairman of the committee.
Thank you, Mr. Sellers.
HB 53, under existing law, it is the policy of the state to ensure that minor children have frequent and continuing contact with parents who act in the best interests of their children. This bill will create a revocable presumption that joint legal custody and substantial parenting time for both parents is in the best interest of the child, except in the case of domestic and family violence. This bill will also require the final order of the court in certain custody determinations to address parenting time during holidays and other matters.
And this is a sub-bill, ladies and gentlemen. You've all been given a copy of this bill. Is there a motion to introduce the sub? Thank you. Is there a second? And there's a second. So there's a motion and a second to introduce the sub. Is there any discussion about that? Seeing none, all in favor say aye. Aye. Any opposed? So Representative Sellers, your sub is in play, and is there anything else you wish to add?
Thank you, Judge, for working with us.
All right, we've got some questions. Mr. Tillman, you had a question?
Mr. Chair, the appropriate time, move on table for report.
Okay, Mr. Brendan?
I have a question. I want to comment. Representative Sellers, I know you worked very hard on this case, on this bill. As you know, I practice exclusively domestic relations and have now for almost 32 years. I've read the bill. I like the bill. I like it in its form that it's in now. I know that what you've essentially done is you're codifying what good judges already do and what some cases have tried to get the judges to do that have come out of the Court of Civil Appeals and out of the Supreme Court. So I commend you for your work. I thank you for bringing this. I think it's gonna help, the domestic relations judges that haven't been doing things extremely well. In some of these smaller counties, it's the district court judge that never practiced domestic relations. And this is gonna give them straightforward bullet point things that they need to be addressing and including in their orders. And I thank you for your work on this. With that, I move to federal tax.
Here we go, I will let you second, Mr. Tillman's, motion. By all means, Mr. Rock.
Reverend Sellers, I have one question, and this is a question of circuit judge that I have that represents his circuit, Coosa and Clay, and he had a question on, and I'll just basically on line 107, that section where court shall designate the parent's residence, which contains the school zone of the child. On which parent are we talking about? If it's if he's not granted in any joint physical custody order, there's not designated primary physical custodian, so you got to designate a primary custodian. So how do you determine which school zone, which parent are we talking about here?
I guess it would go to,
I believe it'd be the primary physical custodian.
But in this case, there's been no designation as the primary physical custodian.
Sorry, correct.
I think that's what it's doing, even though there's not a designation of primary, it's designating one of their addresses for school purposes. So it's not designated primary, but it's for the schools to know what zone they're supposed to be in, the judge can put that in.
court should.
Okay, so really, I mean, obviously, the judge could decide that there's no parameters, the judge could sue his mom or dad.
Yeah.
He or she, that judge would have any choice.
If they, what they think is the better school place.
Okay.
And it not have anything to do with who's necessarily primary or has that designation, but at least gives clarity about where the child should be signed up to go to school.
All right, that answers the question. I can relay that back to him.
Any more questions? Thank you, Mr. Rock. We have a motion and a second for a favorable report. If there's no more questions, all in favor, please say aye.
Aye.
Favorable report is so. Representative Sellers, thank you a lot.
Thank you, Judge.
Thank you, we appreciate it. Senator Van, you ready on? Yeah. Senator Van, please go right ahead. Isn't this pretty much the same thing as House Bill 202?
I'm not aware of the companion bill, but it should be, assuming the same amendment was made, because I think the way it was originally worded was the local law enforcement, and this opened it up to the LEA, something, so the gross version has that.
I think Senator, I believe we did. I believe it is the same bill as came out of our committee.
I did get
The lawyer says it is. Right? Okay, there's a motion for a statement report. All in favor, say aye.
I'm this side. Well, thank you. My old school classmates trying to help me out for once.
And I appreciate you doing that. Ladies and gentlemen, there's a couple of, I meant to say that we're gonna carry over. We're gonna carry over SB 82. Mr. Faulkner is working with that bill. We're gonna carry over SB 358, because Representative Berger asked us to carry that over, so obviously we're certainly gonna do that. SB 118, Senator Bark, you got this? Okay. Hold on. There you go. Okay, I'll get you there. Mr. Brown, please.
Thank you, Mr. Chairman.
Talk about Senate Bill 118.
Sure. Thank you, Mr. Chairman. What this is, if you remember back, we passed the NIAS law out of this very committee in 2021. What this does is just updates a NIAS law, keeps the same standards in place of an evidentiary hearing, and it would include the solicitation, attempt, or conspiracy to commit murder, as well as shooting or discharging a firearm, explosive, or other weapon into an occupied dwelling, building, railroad locomotive, railroad car, aircraft, automobile, truck, or watercraft. And this keeps the same standards as that are currently working with the NIAS law. It just adds those crimes to the possible ones that the judge could have a hearing on.
Questions?
I was just gonna make a motion for the favorable appropriate time.
We got a motion for favorable report. Any questions? Motion has second. Seeing no questions, all in favor, please say aye.
Aye.
Any opposed? Okay, so favorable report, thank you a lot.
Thank you, Mr. Chairman. Thank you, members.
If y'all will look at SB 178, we just took this up on the House floor this morning. It was House Bill 307. No, we took it up Tuesday. It was the one about the speed trial. So it's the same deal. I told Senator Bartlett there's no need for him to come. We got it out of this committee and got it out of the House. Yes, sir. Thank you. Thanks. Yeah, we can put, we sure did, we can,
Replace lines 94, 95 on page 4 with the following through 41-19-12, Code of Alabama 1975, and also add section 3, presiding circuit judge of each circuit in his or her discretion and the best interest of justice may reassign the case to any of the circuit or the chief judge in the circuit without regard to division or speciality. And in section 3, section 4, this act shall become effective on June 1st, and I'm assuming this amendment makes it identical to the bill that passed the House today.
it does.
So, I'll put this amendment.
Amendment is made and seconded. All in favor of the amendment, say aye.
Aye.
Any opposed?
And I'd like to review my motion to give the bill a favorable report as amended.
Favorable report is amended. Okay, any questions? All in favor, please say aye.
Aye.
Any opposed? Thank you. Okay, thank you very much. Senator Kelly. Senate Bill 40, is this the same as yours? Was it the same as yours?
Yes, sir, I do have an amendment. Once we adopt the amendment, this will be an identical to HB 216, the hold harmless agreement related to the suicide, the overall suicide prevention program where you can voluntarily surrender your firearm.
All right, go ahead with you. Walk the amendment.
So I can go through line by line or simply state, the original bill had state and local law enforcement as a part of a place in which you could surrender your weapon. We struck that language from the House version, and so with this amendment, it'll take that language out, and so it limits the participants of the program to be a federal firearms licensed dealer or gun store, and that'll be the location that this program would be administered through. It no longer applies to county and municipal law enforcement.
Okay.
I'd make a motion, so please, the judge.
Second. Okay, the motion made to adopt that amendment, which does make it exactly the same as Representative Betzo's bill.
Yes, sir.
All in favor, please say aye.
Aye.
Any opposed? Okay, so now you make a motion, we give a favorable report as adopted, as amended.
As amended, yes, sir.
All right, thanks. Doug, is there any more questions about this? All in favor, say aye.
Aye.
Favorable report is amended. Thank you, sir. Mr. England, you want to do House Bill 42?
Absolutely. House Bill 42, the bill body bill that was passed out of the House. We got the Senate committee last year, and it just basically restores a couple of words back to the code section that were taken out in a very large bill that was passed a few years ago. And what it does is it essentially allows a judge to assign a percentage bond on a case for cash. And like I said, it's been something that's been done for years. And it's in a bill that was passed a few years ago, it was taken out. So this restores that. And it's really just 3 words. It adds the words "a part of" back to the law. So at this point, I'll open any questions.
Sure.
Questions?
Yes, sir.
Please, sir.
Representative England, is there any, could there be, and I'm just asking this, like whether this is done, like could there be a limit such that, you know, you couldn't go below, say, the current system, as I understand it, what you're changing is that to do a cash bail, they've got to put up the full amount of the bail. As the law stands now.
Well, yes, as the law stands now, yes.
Yeah, that's so as the law stands now, you have, if a judge sets $1,000, you've got to put up the full $1,000 in cash.
Go get a bond.
Or go get a bond. So this bill would allow the judge to set it at any number for the cash.
No, not necessarily, no. Usually, and I think I want to just kind of,
because where I was going to is could there not be a minimum, you know, like where you say, okay, because what I'm hearing is there's a lot of data out there that on these cash, when you do just put up cash, that the rate of failure to appear goes up.
it's not, I mean, that's actually the exact opposite of true. It's the same group of people who who eventually produce that person to court, most times it's law enforcement. So the failure rate on an FTA, in terms of they come back to court or not, generally speaking, the person that produces that person is law enforcement when they get arrested for something else. The only difference would be is if the money that person puts up, whether it be cash or they go to a bondsman, is where it goes. So if you pay a bondsman, instead of the court giving a partial for cash, the court will likely never see that money. But if you do a cash bond, if the person doesn't return to court, the money is forfeited, as we would theoretically do with a bondsman. But the money for cash that you put up to get out is forfeited, and it goes back to the court.
All right, let me ask you this, and you know a lot more about this than I do. I acknowledge that. So if someone does not appear, the bondsman has to pay the full amount of that bail.
In theory, yes.
But if somebody pays cash and you don't, and with this bill, that's allowed now, but you have to put up the full amount to do that. So your bill would change it so the judge can only require that they put up 10%, for example.
That's normal. Yeah,
right, is normal. And so if they don't appear, then all the court has received is 10%. Whereas if they've gone to a bondsman and they don't appear, the bondsman has to pay the full amount of that bail to the court. Is that right?
Again, in theory, yes, but in practice, it rarely happens because we'll have forfeiture dockets in the bonds. The bondsman will show up and the bondsman will say, I don't have that money, and we rarely forfeit. And this is like something that we've been dealing with for decades. And when we were dealing with the court cost issue years ago, we found out that we were millions and millions and millions of dollars in uncollected forfeitures. Because they could write bonds for hundreds of thousands of dollars, but legally they're only required to keep $25,000 in escrow. So a couple of bonds that you may require forfeiture, they may actually, they'll tell you they'll put us out of business, so they'll hardly ever forfeit. And then we've also got some bonds.
Are you saying you hardly ever insist?
So there's some jurisdictions that don't even have forfeiture dockets anymore because it's just fruitless, because they don't really have the money to make those things liquid. So then also, we've also run into the situation in certain counties, in certain circuits, where when we attempt to actually forfeit, we've been sued for a breach of contract to try to get out of paying the forfeitures. So it's, so bottom line really is if somebody's FTAs and we get the cash and they don't show up, oftentimes the only money that we can get from a defendant is the cash they put up to get out of jail.
Could we not raise that above 10%?
Well,
could it not be above? I mean, if you had a minimum amount so that it's got to be a higher amount than 10%.
I just want to also point out the interesting thing about our conversation is the bail bonding companies are empowered to do things right now that judges can't do. Because judges can, bonding companies can take less because some, in fact, do take partial payments on the initial payment to go ahead and get that person out. So effectively, they lower a bond when a judge can't.
So, what do you think about the idea though of it being more to a minimum over 10%?
Well, I mean,
If cash is accepted.
I mean, I guess, but quite honestly, I think judges right now retain the discretion to do OR bonds. They can let somebody out without a bond at all. So, I mean, essentially, and this is why the judges support legislation, the District Attorneys Association support legislation, because oftentimes the cash that's put up is most of the time the only money that the court will get from that case. And even still, what another interesting component of this is that if the person comes back and they're found guilty, they can oftentimes just say, keep the money that I've given you already. So it's really just a distinction of who do you want to get the money. Would you rather go to a private company and we never see it? And then ultimately, we end up doing the work anyway, because sometimes bondsmen don't realize where their client is until they get picked up by another agency. And they show up in court just like they do, and they say, well, here he is. Or would you rather a judge who actually knows that person and is making the assessment based upon that risk that person presents versus how much money they can pay me, making a decision about how much that percentage of that bond should be? This, to me, it sounds like a better interest decision based on public safety would be the judge who's familiar with that person, making a decision, okay, here's your percentage bond, if you give me this much money, you can get out, versus somebody who's only interested in making sure they make money off of this case, making that decision, and then effectively lowering the bond that the judge can't do right now. So to me, in the interest of justice and public safety, it would make more sense that the person who's most informed about the status of the defendant and their ability to either re-offend or to come back to court makes a decision, hey, you pay me 10% cash and you can get out, versus going to a bondsman who may not even require them to pay the entire amount to get out in the first place.
And I thank you, because that is helpful. Judge, I don't know, this is a, this minimum idea of it just being 10% is what seems to bother me, is that I guess the judge has the discretion, if Chris' bill passes, to put it at whatever level